Good afternoon. So I would like to take this opportunity to introduce our speaker. It is Mark Fessler. Mark is the Deputy Director of Litigation and Training at South Carolina Legal Services. He graduated from USC School of Law and was admitted to the South Carolina Bar in 2008. His practice has focused predominantly on housing and housing law issues facing low income tenants and homeowners. He was named SCLS New Lawyer of the Year in 2012. Mark became SCLS's lead foreclosure attorney in 2015, and he became head of the housing unit in 2018, which position he held until August of 2022, when he stepped into his current role. He also has been a member of the SC Bar's Consumer Law Council and formerly served as a member of Legal Services Corporation Eviction Study Advisory Board, where he helped to advise a congressionally directed study aimed at investigating the unmet legal needs surrounding eviction in the United States. After Mark gets up and speak, he will give you the opportunity at the end of his presentation to ask questions. So if you'll hold all of your questions until the end, at that time he will address them. If you please join me in welcoming Mark Fessler to the stand.
Thank you for that kind introduction. And I am Mark Fessler. I'm, as the person who introduced me said, with South Carolina Legal Services. And this will be my third, maybe fourth time. I'm not sure. Fourth time? Okay, I've been told fourth time being invited to give a little talk about some fair housing topics at this event. And it's always a pleasure. And there's always a good crowd turnout. So it's always nice to come out and see the faces of the people who operate sort of in and adjacent to the same kind of spheres that I do. I know some of you might be landlords and maybe we might be on the opposite sides of cases, but it's all for the purpose of getting the right outcome. At least that's how we lawyers try to look at it. It's getting the right outcome. So when I was asked to do a presentation this time, I kind of think back over what are the issues that have come up in my practice, in legal services practice over the last year. And one of the issues that was kind of at the forefront was support animals. And really, what do you do if a support animal is accused of being overly aggressive or a danger or a threat or something like that? And so I was able to kind of do a deep dive into what courts have analyzed regarding that issue, what the rules are regarding that issue. And I thought it might be an interesting topic for this crowd to kind of think about and talk through. So that's why we chose lions, tigers, and bears, if anybody gets that reference. Oh my. A look at assistance animals under the direct threat fair housing rules. And let me see, I think this is the clicker. Perfect. All right, so to kind of give you an overview and a roadmap of what we're going to talk about, it's just we're going to start with the basic rule, which I'm sure y'all have probably heard, before now this morning. And then we're going to focus in on the direct threat exception. And then we're going to pivot and apply that exception specifically to assistance animals. We'll talk about what they are and the circumstances under which the direct threat issue can come up relating to assistance animals. And some issues that come up within that conversation are, what types of animals can you have that qualify as an assistance animal? What kind of restrictions are permissible or not permissible related to assistance animals? What happens if a dog bites somebody? Is that it? One strike? We'll talk about that. And what are the rules around landlord liability when an animal, acts up and causes injury? And what are some insurance concerns that might arise? So that'll give you an overview of what we're going to talk about. And this talk primarily comes from two sources. So when I read over the cases, even the courts that analyze these issues refer back to two main HUD sources. One is the joint statement from HUD and DOJ, which was issued in 2004, and it's an FAQ, and it goes through a whole series of, what is a disability? What can you ask to determine what a disability is? So it's the whole slew of rules on reasonable accommodations, and courts refer to that programmatic guidance regularly. Also, HUD issues fair housing and equal opportunity notices. The most recent one was from 2020. So a lot of this is drawn directly from that guidance. Some of the HUD notices that preceded that were from 2013 and some earlier dates. There isn't a lot of changes between the earlier guidance and the 2020 guidance, but the 2021 is the most recent and up-to-date guidance on assistance animals. So, as you're probably aware, the basic rule is that it's unlawful for a provider of housing to refuse a reasonable accommodation to rules, requests, rules, policies, practices, or services when that accommodation is necessary. So it has to be necessary, and it has to allow somebody with a disability to enjoy housing to the same extent, not necessarily to a greater extent, but to the same extent as a non-disabled person. So there are a couple of key things to keep in mind there. One, the request has to relate to a rule, policy, or practice to be a reasonable accommodation. Of course, there are reasonable modifications, and that's beyond the scope of this, but an accommodation is to rules, policies, practices, or services. The person has to be disabled, which means that they have a significant limitation that significantly limits a major life activity. And then the accommodation has to be necessary. So there has to be a connection between the disability and allowing that person to enjoy housing to the same extent as a non-disabled individual. And if an accommodation would impose an undue financial or administrative burden, then it's not reasonable under the Fair Housing Act. So you'll notice there that there might be a potential for some sort of financial burden or an administrative burden. I mean, making an accommodation by its very nature is going to impose some sort of burden on the housing provider. But the concept here is that it has to be undue or unreasonable financial or administrative burden. So the direct threat exception to that says, and this is probably the very last statute in the Fair Housing Act, and it says an accommodation is not reasonable if it poses a direct threat or would result in substantial physical damage to property. So, you have to grant the accommodation if it's necessary to allow somebody to use the property unless the direct threat exception applies. And the direct threat analysis that HUD has established for this is multi-factored. So it's not just oh, the dog barked one time or, tore up the blinds one time. There are several levels of analysis that must be conducted before you can determine whether something is a direct threat. And this doesn't just apply necessarily to animals, it applies to any sort of situation. So a lot of the direct threat cases that are out there actually involve human beings or people that have acted in a violent way. And there's issues related to mental health and whether medication can address the situation, or somebody's unable to maintain an apartment, and whether or not help can be brought in to address that sort of situation. So this analysis applies not only to animals, but to all direct threat or alleged direct threat scenarios, across the board. You have to first look at the nature of the risk. So what risk are we talking about? Are we talking about physical injury? Are we talking about damage to property? Are we talking about, something that draws blood? Or are we talking about, something that's less of a severe risk? What is the duration of the risk? How long is this risk intended to or expected to last? Is it something that's going to be perpetual 24/7, or is it something that might crop up, once in a while? How severe is the risk? Is this going to be something that somebody could end up in the hospital over, or is this going to be something much less significant? So you have to analyze all those conditions of the risk. What's the probability that it'll occur? Is it a 5% chance, 50% chance, 100% chance? Those questions are relevant to determining whether a direct threat exists. And also, are there things that can be done? Well, let me back up. So let's assume that, the nature's severe, the duration is, we check all the boxes for steps 1 and 2. But then you have to also go a step further and say, are there things that can be done? Reasonable things, because, not everything is reasonable, but are there reasonable things that can be done to significantly reduce or eliminate that risk? And even if the requested accommodation poses a significant risk, if you can take a step that's reasonable that will eliminate that risk, then the direct threat would not apply in that circumstance. And also, HUD cautions in the joint statement not to use fear or speculation or stereotype about the particular risk. So we'll talk a little bit later about, ordinances that might say nobody can have pit bulls. We're just going to assume that all pit bulls are bad, and we're going to ban them as sort of a breed restriction. Is that a stereotype that is improper when assessing a particular reasonable accommodation request? And finally, the evidence that you rely on to determine that there is a direct threat must be reliable and it must be objective. So it can't be one-sided. Everybody involved in this analysis should have an opportunity to explain why the accommodation is reasonable or is not reasonable, on the other hand. So before we get to the direct threat as applies to assistance animals, here's just a quick refresher on what assistance animals are. In the Fair Housing Act world, there are two types. This is a little different than the ADA, which applies only to public accommodations, hotels, things like that. But fair housing applies to the most intimate parts of where we live and operate, our homes. And so there are really two types. There's service and support animals. And service animals track exactly with what the ADA, the Americans with Disabilities Act, says a service animal is. It has to be a dog. So is it a cat? It's not a service animal. Is it a turtle? Not a service animal. It has to be a dog, and it has to have training that conditions it and allows it to perform at least one particular task for the disabled individual. If those conditions are not met, then it is not a service animal under the ADA. And HUD's guidance suggests that when you're trying to determine whether something is a service animal, it's permissible to ask, is the animal necessary because of a disability, and what work is the animal performed to do? So we see that question about the work that an animal is trained to do come up a lot with this other type of assistance animal, which are support animals. Support animals are other animals that do work, so they can be a service animal, or they can, simply provide assistance or provide therapeutic emotional support for individuals with disabilities. So you have service animals on the one hand, and then you have support animals, and both of them combined are what HUD calls assistance animals under the Fair Housing Act. They can be a dog, they can be any other animal that is traditionally kept at home and domesticated. So that's kind of the broad umbrella term for what a support animal can be. Examples given, you'll see cat, small bird, rodent, hamster, gerbil, ferret, maybe. I had a friend that had a ferret growing up. I know that could, I don't know if that's traditional, but it wasn't. Although it did kind of get behind the cabinets a lot, and it would kind of, hide out in odd places. Anyways, reptiles and other types of animals, other than turtles, are generally not considered common domesticated animals. So if someone comes to you and says, I got a little bear cub, unless we're living in the tundra of Russia, that is probably not a common domesticated animal. And yes, I did see a video just yesterday about a Russian couple that had adopted a bear cub and had raised it to adulthood, and they got along just fine. So different strokes for different folks, I suppose. One issue that comes up is this issue about whether assistance animals are pets. I was listening to a hearing the other day, and it was a magistrate court eviction case, and there was this whole back and forth about whether the pet policy applied. And that really misses the point. So I just wanted to point out that HUD says assistance animals are not pets. But what does that mean? It means you can't charge a pet deposit that you would charge for other pets for the assistance animal. But it doesn't mean that every policy in the pet policy is jettisoned, that there's no compliance needed with all those other policies. I think the key thing to keep in mind here is not so much, is it a pet versus not a pet, therefore does the pet policy apply versus doesn't it apply? It's to look at each individual policy and say, is this a reasonable policy to apply to somebody who needs this animal? Would applying the policy prevent the disabled individual from keeping the animal or from being able to use the animal or enjoy the animal as needed medically to enjoy housing to the same extent as a non-disabled individual. So I think, it's a surface level analysis to simply say assistance animals are not pets and then try to question whether the pet policy applies. Look at each individual policy and look at the specific accommodation requests that the person is asking for to determine whether or not it's reasonable to accommodate that particular request. So for example, if somebody says, well, I would prefer not to have to walk my dog on the leash. Dog, it walks right next to me. It's fine. It's never going to run away from me. It's all good. Is it reasonable to say, well, you don't have to follow the leash policy, and the person might say, well, if the leash policy is in the pet policy and the dog's not a pet, then I don't have to follow it. No, not necessarily. Cleaning up after the dog, sanitariness and health and safety, those kind of things, those kind of rules apply regardless of whether the policy is designated as a pet rule or just a general rule applicable to everyone. The limitation on the numbers of animals, does one person need 10 different animals to satisfy a particular disability? At some point it does become unreasonable. So the point here is just to sort of look at each policy individually and make an independent judgment call as to those particular policies. So is the direct threat exception a limitation on assistance animals? Yes, everybody, no surprise there, it is. And you have to run through the same analysis that we talked about earlier. What is the risk? What is the nature of the risk? The duration of the risk? Severity of the risk? Is it that the dog's going to be barking and keeping people up all night, or is it the dog's gonna bite somebody? Those are different risks. So determine what the risk is, figure out what's the likelihood that it'll occur, and run through the three-step analysis that we talked about earlier. And I wanted to draw this particular case just to really emphasize the point that the analysis cannot stop at, yes, this dog poses a risk, or this other assistance animal poses a risk. It has to go beyond that and look at whether there are steps that can mitigate that risk. And the Federal District Court in New Hampshire specifically made a ruling to that effect. And the Sugar River case involved a human being that was alleged to have been a threat. And the court noted HUD's policy, and that really is the congressional policy, of avoiding decisions that are based on stereotypes, prejudices, or irrational fears. So this person just doesn't act right, or I know his mama, or whatever, those kind of things are not grounds for denying an assistance animal to somebody or any other reasonable accommodation request. So there was one case I was able to find where the court found that the landlord had proved that a direct threat existed. And what I want y'all to pay attention to and sort of keep in mind here is the court doesn't rely on just one thing. The court runs through that entire analysis, and there are a lot of different facts that support the decision to deny the dog as a reasonable accommodation. So in this case, the dog's name was Duchess. How cute. And I think it was a pit bull. I don't really have the specific dog there, but the dog would regularly, there was evidence in the record that the dog would regularly rear up and bare its teeth at people. That the tenant told the other dog, hey, this is a guard dog, it's not my emotional support animal, this is here to protect me. So that's a little not, doesn't correspond to what the dog is supposed to be doing. Other residents were scared of the dog and would stay indoors. And I believe the evidence was also that the tenant would specifically try and walk the dog at times when other residents would not be around so that there wouldn't be, this rearing and gnashing of teeth. To speak biblically. So the residents were afraid of the dog, and it wasn't an irrational fear, it was a real fear. And finally, there was an issue with whether the dog was controllable because the tenant had a medical condition that potentially limited her ability to control Duchess. And so in that case, the court said, yes, the trial court was justified in finding that this dog was a direct threat, and therefore, because the tenant didn't get rid of the dog when requested, the tenant, in that case, the eviction was upheld. So dogs, fine, but what about unique animals? So the lions and tigers and bears, that's a bit of a hyperbolic statement. I don't know. Has anybody had what's the weirdest animal somebody has asked to keep as a accommodation? A what? A pig or a mini? No, well, I don't know about pigs. Mini horses are adorable. But yeah, so they would fall under the category of unique animals, I believe. And so what HUD says about unique animals is that probably not, but it's not a definite no. First of all, the burden is on the requester to justify why they need a unique animal. But HUD does give an example. So a capuchin monkey, which I had somebody make these slides, so I'm assuming that's a capuchin monkey. If anybody is saying that's not a capuchin monkey, I apologize. A capuchin monkey can perform tasks for somebody because it has, an opposable thumb, and it can grasp a bottle of water and unscrew it for somebody that's paralyzed and help them get a drink of water. So that's an example that HUD gives of a situation where a unique animal is a reasonable accommodation. An example of where a unique animal is not a reasonable accommodation was in the 2006 case out of the Western District of Washington, where the tenant wanted to keep several snakes as emotional support creatures. The landlord in that case said, okay, well, we need confirmation that these things are not poisonous, that they're not going to injure anybody. We also need you to explain why snakes can alleviate the symptoms of your disability. Explain that connection. That's not real clear. The tenant did not provide that explanation and instead sued in federal district court. And the court sided in this case with the landlord and said, look, if you can't demonstrate why this particular creature is not a threat to other people and why you need this particular creature, then the landlord's decision to not allow it is a-okay with the court. So another question that comes up are breed, height, and weight restrictions. Some of the cases here don't necessarily involve landlords, but involve condo associations. The Fair Housing Act applies to housing providers of all sorts, not just landlords, but condo associations as well. So the same rules are going to apply regardless of which party you're talking about. And in this case, it was I believe it was a weight restriction. And the rule was that you can't have a dog that's more than 25 pounds. And this individual, Mr. Bagaida, was an Air Force vet, had PTSD, struggled with social interaction issues, and had a dog that helped alleviate those, supported by medical advice from his doctor. But the dog was more than the 25-pound limit. So the condo association said, well, Mr. Bagaida, you're happy to live here, but you can't live here with the dog. Got to lose the dog. So what did the condo association proceed to do? And I kind of included this slide because in reading through the case, it was really a list of what not to do. So kind of like the video we just watched, there were a lot of things. Yeah, don't do that. I heard people saying, oh yeah, that's obvious no-no. Well, these are a lot of obvious no-nos. The condo association comes back to Mr. Bagaida and says things like, how long have you been receiving treatments for this specific impairment? Not an appropriate question. You can establish that there is a disability, but you can't go into intimate details about that treatment. How many sessions have you had with your most recent doctor? Why do you have to have a dog that's over 25 pounds when you could get a different dog? That one, given a different factual circumstance, that may not be inappropriate, but it wasn't appropriate in this case. Well, Mr. Bagaida answered those questions, or through his lawyer answered those questions. Then the condo association, through its lawyer, said, not good enough. We have a whole list of other questions we need you to answer. And none of these I don't see are relevant. What is the exact nature of your mental disability? What medications are you taking? How was your diagnosis made? Let's give a dissertation on the psychological analysis. How often do you see your doctor, and how many treatments do you get? I mean, all of these questions are way beyond what you reasonably would need to establish that there is a legitimate, valid disability. So rather than answer those questions, what Mr. Bagaida did through his attorney is he filed a complaint with HUD, and then he filed a lawsuit in district court. And they had a jury trial on the matter, and the court found, another interesting thing about this case was the condo association never said no. They just asked all those questions, and Mr. Bagaida said, forget this, I'm not answering these questions. And the court determined that that was a constructive denial. By not granting or denying the accommodation at the point that the condo association had enough information to determine, is there a disability and is this accommodation necessary to address the symptoms and conditions of that disability. The court said by continuing to ask questions that you're not permitted to get answers to, that is a constructive denial. And at that point, the fair housing cause of action existed. So the jury awarded Mr. Bagayda $5,000. But they awarded the attorney, well, the court awarded the attorney after the case $100,000. So these are not, or can be, high dollar issues. So it's important to know where the line is and to be careful about crossing that line. So the next issue that comes up is the breed restrictions. And this has been an issue in several city ordinances, cases that we've seen. So one, the city of Arapahoe had a ordinance against pit bulls. And in this case, the facts were different. So the individual had been paralyzed for 35 years. And the dog that, the pit bull in question had only been in the homeowner's possession for 2 years. Prior to that, the homeowner had another dog, which complied with the ordinance, for 5 years. And so in that case, the court said, well, you had another dog prior to when this ordinance took effect that addressed the symptoms of your disability. So the court found that this particular animal was not necessary, that there was no necessary causal connection between the dog and addressing the paralysis and the frustration from being unable to perform certain tasks. So the factual context of these cases does matter, but this is, I think, a fairly extreme example of where, you've been living with this condition for 35 years or 33 years with a different type of animal. Is it reasonable in that case to accommodate the request? And the Supreme Court of Nebraska held that it was not reasonable because it was not necessary. So then that gets to the one strike question. All right, well, if the dog bit somebody, the dog has got to go. There's no question, there's not even a discussion to be had. And we find a case out of the appellate court in New York says not so fast. So in this case, the New York Housing Authority was trying to terminate the tenancy of an individual whose dog had dashed through a door and had bit a housing authority employee. The housing authority terminated the dog, saying that it was unauthorized, that it was a vicious dog, that the tenant failed to control the dog or to register or maintain the dog. And at that point, the tenant notified the landlord that it was a support animal, that the tenant needed the animal as a reasonable accommodation. In public housing, you don't automatically go to court necessarily. You can have an administrative hearing through the public housing authority. So that's what happened in this case. There was a hearing officer, and the hearing officer held that because the dog bit somebody, it was a dangerous animal and it had to be removed. But the hearing officer did not consider the 3 elements that the HUD rules require to be considered. And so what the appellate court did is the appellate court reversed that decision. And it specifically cited HUD's rules, and it says, we're not going to say that the dog's not vicious and that the dog is not a direct threat, but you have to go through the analysis. If you don't run through the analysis, then you have not followed the process that you're supposed to follow in order to make that conclusion. And so the court said a housing provider can only invoke the direct threat exemption after conducting an individualized and objective assessment of the animal, which includes all the factors that we talked about: nature, duration, severity, probability that the injury will occur, and is there any accommodation that can mitigate that risk. So if the issue was the dog jumped out of the door and bit somebody, is there a way we can hold the dog, or can we put like a child's gate? I had a case where the issue was the dog had run out, and so we said, all right, well, why don't we put a child's gate in front of the door, and that way the dog can't jump. It's not big enough to jump over the gate. So would that not mitigate the risk that any of these issues will occur in the future? So that's the one strike issue. Is yes, that is a serious thing, and I'm not here to say, dog bit somebody, and it's fine. But it does require something more than just that one instance. It requires this full analysis. And so then you might be thinking, well, if I'm a landlord and a dog bit one of my other tenants and I keep that dog around, I'm going to get sued. So that's crazy. Why would that be permissible? So here I'd like to take a poll, just an informal poll by show of hands. In South Carolina, we're going to talk about South Carolina law next. In South Carolina, is a landlord liable where the landlord knows of the dog's dangerous propensities, has time to require the tenant to get rid of the dog or evict the tenant that did not get rid of the dog, and then the dog jumps over a fence and bites another tenant's child? Is that landlord going to be liable to the tenant whose child was bitten? Yes? All right. No? All right, there were a little bit more no's. Okay, but not even. Well, the answer is no. This comes from a specific case, and the law in South Carolina about landlord liability for a dangerous dog is very generous to landlords. And in this case, Mitchell v. Bazell, a 1991 Court of Appeals case, the landlord knew about the dog's propensity. The dog jumped a fence, bit a child, and the landlord was not liable. Now, the tenant, of course, that's a different story, but the landlord in that case was not liable. The Supreme Court and our Court of Appeals has even reaffirmed this ruling in several other cases. So in Fair versus United States, the argument was that because a landlord has the obligation to keep premises fit and habitable under the Landlord-Tenant Act, a dog that bit another tenant, that the landlord violated that rule to keep the property fit and habitable. And so the South Carolina Supreme Court said, no, the fit and habitable rule refers to things like walls, windows, the physical structure of the property. It doesn't apply to animals. So you can't use the obligation to keep a fit and habitable property as legal grounds to sue the landlord when a tenant's dog bites somebody else. In another case, Gilbert v. Miller, the issue was that the lease itself talked about restrictions on the dog and how the dog can't tear up things and the dog has to, not damage property, etc. So one tenant's dog bit another tenant's friend at the friend's house, and the friend sued the landlord. And they said, well, you have in your lease rules that say the dog can't act up. And the Court of Appeals in that case, again, relying on Fair, relying on Mitchell, said, look, the lease was not designed to address that type of situation. The lease was designed to protect the property from being damaged. So we're not going to allow a third party to rely on a lease that they're not a party to sue the landlord over the dog bite. And there was also another case, which I don't mention up here, where the Court of Appeals basically just said, yeah, we're sticking to the landlord's not liable if the dog bites somebody else. However, there is an exception for common areas. So in the Clea case, the dog was tied to a tree for, I want to say, a very long period of time, several years, I believe, and the landlord knew that the dog was vicious. So in the Landlord-Tenant Act, there's a rule that says landlords have to keep common areas in a reasonably safe condition. And the court there said, okay, when it's in a common area and the landlord knows about it, because the landlord has an obligation to keep common areas safe, liability could extend in that circumstance. So that's what South Carolina law says about landlord liability. And then finally, you might say, all right, well, I'm not going to get sued, but my insurance rates are going to go way up. I'm not going to be able to find insurance. I'm going to have to, pay an arm and a leg more than I was paying before. HUD has addressed this to some extent in a brief memo that they issued in 2006. They said that it will be unreasonable to grant an accommodation to allow a particular animal if that would cause an insurance provider to cancel or to substantially increase the cost of the insurance, or adversely change policy terms based on the breed of a dog or a certain animal. However, the housing provider would have to demonstrate that there is no comparable insurance, that there's no reasonable alternative to that. And HUD ended the memo by cautioning insurance carriers that they cannot have blanket rules that simply say, if you have X type of animal, we're not going to insure you, and asked people to report that to DOJ if they come across such rules. So that gives you a quick, simple overview of reasonable accommodations as it relates to assistance animals and direct threats. I'm happy to take any questions anyone might have, And if not, I'm happy to pass it off to the next person. Yes, sir.
So one issue that has emerged for landlords and property managers, particularly as it relates to emotional support animals, is the availability of fake letters that people can buy on Google indicating that, an emotional support animal is necessary. What steps legally can a property manager or landlord take to verify that this documentation is legitimate?
Right, so that's a good question. And, the landlord can verify. Well, if it's not coming from a medical doctor, that's, one question. So who is drafting this letter? So the two questions are, is the person disabled? The letter could be addressed to two issues. Is the person disabled? They're probably addressed to both issues at the same time. Disability and the necessity of the accommodation. So if it's a medical professional or some sort of licensed, therapist or something like that, you probably take the letter at face value, unless you have conflicting information that, expressly contradicts what that letter says. The landlord does have some limited ability to reconcile conflicting information. But if a letter, came across my desk and says, this person needs this particular animal to address PTSD or some sort of non-observable disability, what are the credentials of the individual offering the letter? I think that's an entirely reasonable question to ask. So what did the tenant do, or what did the person do to allow the person giving the letter to provide accurate information? Did the tenant, was the tenant seen by this, website? I'm not familiar exactly with them. I'm thinking of like telemedicine. So there are scenarios where people can be, treated or seen over the internet. But if it was just pay me $50 and I'll write you a letter that says whatever you want it to say, I think the landlord or the person being asked to give the accommodation can discount that as not a credible source of information. Yes, ma'am.
Just to piggyback off of what he had said, if someone has the suspicion of it being a forged letter, what is reasonable in terms of calling to verify the letter or checking in with that professional?
Sure. So there's this process that HUD talks about and advocates for called the interactive process. So you've presented me with X, Y, and Z information. I have some questions, not the questions that the condo association in Begida had. How many times are you being seen by your doctor? But I have questions about whether this is from an actual doctor. Would you mind if we got on the phone with your doctor? And in fact, in the Begida case, the Begida's attorney suggested to the condo association's attorney, look, let's do a three-way call with his doctor and you can hear straight from the horse's mouth about all this. So I think it's okay to ask reasonable questions if there is a reasonable suspicion that the information is forged. Then that, of course, again, the denial cannot be based on stereotype, irrational suspicion, or fear. So the touchstone of all this is reasonableness. Is it reasonable to have that suspicion? Not just, I would like more information, so I'm going to say it's suspicious, but is it reasonable to have that suspicion? And if it is, then I would say engage in an interactive process and say, I'm a little concerned about this. Can I reach out? Would you give me permission to reach out to your doctor? Or could we have a conference call with the doctor just so I can verify what this letter says? And see where that goes.
All right, let's give Mark a round of
All right.
applause.
Thank you.